Good afternoon, everyone. Good morning, wherever you are. It's James Slotnick here with Sun Life. We are very happy that you've been able to join us for our fourth annual compliance review. We have it's going to cover all the key absence management changes that have happened, disability developments. What's exciting today is you're not going to hear much from me. I know, disappointing for some, exciting for others. The stars of today's show are Marge Robertson, one of our senior counsels, Abby O'Connell, another one of our senior counsels, maybe two of the most respected. I was told that this picture may or may not be used. Senator Sanders will not actually be making an appearance today, although I think this may be, we maybe should have another picture of the, jumping the shark. Maybe this ends the Bernie Sanders meme for many of you. But as I mentioned, Marge and Abby will both be talking today really with a look back at all the things that happened in 2020 that are still impacting you and your employees, and also a sneak peek into what potentially could be coming down the road in 2021 as well. Before we get started today, and I turn things over to Marge, we've done so many webinars over the past, geez, it feels like it's almost 12 months now. We wanted to change things up. Sun Life webinars usually don't have any poll questions involved, but we thought we would try to make this a little more interactive today. We're going to start off with this question here. What do you find most challenging about applying government and public health emergency orders and recommendations about COVID-19 in the workplace? And that well, in a second, the choices will pop up there for you. You can just click on any of those three. We have employees. It's hard to stay on top of these things, and other ones we have staff that monitors these. And of course, we're not able to allow many of workers to telework because of all the different compliance things. As you're answering those questions, I just want to remind you, as we go through the presentation, if you have any questions, go into the Q&A box. We're going to save some time for questions in the middle, and then we're going to have some time for questions at the end. We're also going to record today's webinar. The recording and the slides will both be posted on our website, www.sunlife.com/coronavirus. We get a ton of great information there. And then after, when the survey is over, when the webinar is over, there'll be a link that pops up for you to let us know how we did, what you'd be interested in hearing more in the future. So we can see there on the slides, looks like 50 more than so about half of the respondents are saying we have employees multiple places and it is hard to stay on top of all the requirements. Well, have you come to the right place, regardless of what you answer there, because Marge and Abby are going to cover everything that you need to know. So with that, I'll turn it over to Marge, and I'll talk to you again about halfway through.
Thanks. Oh, too fast on the draw there. Thank you, James. We are excited to have James with us. He's a real celebrity on Sun Life webinars, so we feel honored by it. We have a lot of material today. And one of the warnings I want to make is that our slides tend to have a lot of content on them, but we don't bore you by reading it all. We take a view that slides should serve two purposes. One is to provide some talking points, but also for you to have as resource materials. And in fact, a lot of this slide deck you're not even going to see today because it's the appendix where we've included detailed descriptions by state of recent COVID changes, and it also has hyperlinks so that you can get access to the materials. But we're going to cover most recent COVID-19 changes, talk about vaccines, give you an overview of important federal and state leave changes and accommodation changes of the last year. And then we'll have time for what I think a lot of people enjoy is the entertainment of discussing some jury trials and settlements.
Great, thanks. So moving right to the next slide, Marge mentioned the huge number of laws, and we have created an appendix because initially this spring and summer we saw new laws related to COVID on the state, city, and county level. And then in the fall, when we had sort of infection rates climbing again and more information was available, we experienced another round of COVID-19 related rulemaking. So we put together an appendix. It's at the back of the slide, and there's details for the states shown in orange here below.
So we don't have time in an hour to go through all of the different orders, but we tried to go through and pull out some of the trends that are happening. And what we've seen is that more and more states and cities are moving to put more of a burden on employers to actually do things other than putting up separating dividers. So these detailed written risk assessments are becoming much more common. Creating written COVID-19 prevention programs and also having to train employees has become important. California, not surprisingly, is leading the way in terms of being the most creative on this. And they have created, among other things, something called exclusion pay. So under these orders, you need to make sure employees are removed from the workplace when they have symptoms or they're exposed. California says you have to pay for the testing, you have to allow the testing during working hours, and if they're excluded, you've got to pay for the time that they're out of work. Only if they're able and available to work. So if they're actually sick, they may be eligible for some other benefit, but they wouldn't be eligible for exclusion pay. But if you're keeping them out of work, they would otherwise be able to work, but they're under some type of quarantine, you may have to pay them. Also, these orders, really important. They're telling you to continue to allow telework as much as possible. There is going to be litigation in the future, and now, I would say until 2021, about employees who want to telework and employers who want them to come back in the office. Be mindful that these orders are telling you you need to allow telework as much as possible, and employees will be able to point to that if you end up in a dispute with them that ends up in court.
So putting together some more information on mask wearing, some mask orders mandate that masks are worn inside and even outside when physical distancing is not possible. And as an employer, you may get accommodation requests from employees who are asking not to wear a mask due to a medical condition. And you've got to be mindful that there may be constraints in place for asking for documentation of that condition, or even constraints on requiring the disclosure of the underlying condition. And if you do end up making an accommodation to relieve somebody from wearing a mask, to relieve an employee or a visitor from wearing a mask, you've got to adopt measures to protect others in the workspace. A new trend that we are seeing, and it was actually in the Boston Globe this weekend and all over my local news last night, is that the trend in wearing double masks, as we're starting to see some of these more contagious variants of the COVID-19 virus emerge.
Yeah, Abby, that's a great point, because what we see is these things evolve. And so I think it's entirely possible we're going to start seeing requirements of double masks. But the most exciting thing that has happened is President Biden on January 21st signed an executive order relating to protecting worker health and safety. And he's actually ordered OSHA, the Occupational Safety and Health Administration, that within 2 weeks, they've got to figure out whether there should be enhanced and nationwide workplace safety standards for employees because of COVID-19. And if so, they need to issue those standards by March 15th. He has also ordered that the enforcement efforts need to be reviewed and ramped up with a particular focus on violations that put a large number of workers at risk, but also on anti-retaliation principles. So I just make a note that in the prior administration, this is not a political comment, but there was criticism of OSHA that they weren't taking as active an approach with regard to workplace safety. In fact, the reason that the federal government last year really stepped back, and that ended up in all of these state and local rules. I think that we could start to see a shift this year where we're getting more federal rules. That may be of some comfort to those of you who have multi-state operations. It may increase your compliance requirements, but at least they'll be consistent and easier to follow.
Great. And so with that, we're going to move a little bit towards talking about immunity from COVID-19 lawsuits. Some states have adopted immunity laws or have had executive orders granting legal immunity from certain COVID-19 related claims. And so here we show some of those states with those laws. States in yellow have immunity laws impacting healthcare providers and PPE providers, and states in teal have broader business protections. It's important though to note that the protections are not going to apply to willful and reckless conduct by the employer or apply also to workers' compensation claims.
So Michigan is the most recent state to adopt an immunity. There are a couple of laws that provide immunity. Michigan's actually a state that's kind of gone through a seesaw. Governor Whitmer issued some very employee protective orders, and then some of those aspects ended up being repealed or essentially overruled by legislation that she did end up signing. I think a couple of things that are interesting about this new law is it extends immunity if the employer was following COVID-19 requirements. They also say, and I'm not aware of this in any other law, that if you have an isolated deviation from compliance, that's not going to destroy your immunity. All of these immunity laws, though, important to bear in mind, they don't relieve an employer from a workers' compensation claim. And so it is not a complete freebie in any sense with regard to employee safety, so you need to keep that in mind.
Great. So we spent a lot of time last year talking about the Families First Coronavirus Response Act, which we call the FFCRA. And just wanted to note that the FFCRA expired at the end of 2020. It expired on December 31st, 2020. But employers have this interesting option where they can voluntarily provide FFCRA leave and then seek a tax credit for that leave that's granted between January 1st, 2021 and March 31st, 2021. So the Q1 of 2021, they could grant this leave and seek a tax credit. Importantly, employees are not entitled to additional time if they previously exhausted FFCRA leaves that were available to them. There's also no right to reinstatement for FFCRA leaves that are granted in this January, February, and March. Also of note, it appears that an employer cannot deduct time from the employee's available regular old FMLA 12 weeks. So the employer cannot deduct time, it appears, from the employee's available FMLA allotment based on the granting of this voluntary FFCRA leave in first quarter of 2021.
So this is a slide with a lot of text, but it comes down to the basics. President Biden has made clear pretty early on, January 15th, he was still President-elect Biden at that point, that he intends to really advocate for having not only reinstating the FFCRA, but significantly expanding it. In his proposal, he would expand it to 14 weeks of paid leave. And if you remember, the FMLA paid leave under the FFCRA only covered one reason. It was if you were a parent and you couldn't work because your child's school or place of care was closed. Well, he's proposing that all the FMLA reasons, essentially, as long as it's tied to COVID, now become paid leave. He's increasing the benefit. He's getting rid of the exemption for employers who are more than 500 employees. He is going to continue the tax credit, but only for the smaller employers. And he wants to get rid of the provision that allowed employers to exclude healthcare workers and first responders. It's going to be an expensive proposal, and I don't know how far it will advance, but it's important to know it is on the agenda.
So even though the federal mandate is gone and there has not been a new clear replacement yet, despite Biden's proposal, it's important to keep in mind that there are state mandates. And the first one that we're going to address today is Colorado. Colorado passed an emergency paid sick leave mandate in 2020, which expired at year's end. But they also passed a paid sick and safe time law, and that's effective January 1st, 2021. For employers with 16 or more employees. And the effective date of the paid sick and safe time law for employers with less than 16 employees will be 1/1/2022. The paid sick and safe time mandate includes the ability to use paid sick time if the employee's place of business or the employee's child's school is closed due to a public health emergency. So they were definitely keeping that kind of public health emergency pandemic leave reason in mind when they passed this law. In addition, Colorado also passed a very specific public health emergency leave, and that's also effective January 1st, 2021. And that will require employers to supplement paid sick and safe leave if needed, up to 80 hours for full-time employees in the event of public health emergency.
So this slide, don't get scared by it. It has a lot of text, but I'm going to kind of hit the highlights. It's really emphasizing to you, especially for those multi-state employers, that just because the federal leave law currently isn't a mandate, there are still lots of places where there are mandates related to COVID-19. State of California actually had a COVID-19 paid sick leave law, but it expired like the FFCRA did on December 31st. And so far, the state law has not been reinstated. But all those cities and counties in the left-hand column, the ones that are in red, they have all extended their laws beyond December 31st, 2020. The other two counties are considering it. They haven't done it yet. New York, New Jersey, District of Columbia, Oregon, and Pittsburgh all also have laws that provide certain paid time off due to reasons related to COVID-19, whether you yourself, the employee themselves has it, or in Oregon's case, they actually expanded their unpaid FMLA, which is 12 weeks, to continue to cover parents who cannot work due to a school or place of care closure. So we had a last minute slide added this morning. I torment the technical people on these webinars by changing things, but New York issued some pretty disturbing guidance, I think, for employers. It's going to have a significant impact. They've had a COVID-19 paid sick leave law since March. But it was interpreted pretty narrowly, that it only covered employees who were subject to an actual order from a Department of Health to quarantine or isolate due to COVID-19. Well, this new guidance is now expanding it significantly. They're saying, first of all, it's not just one order. An employee can take the 14 days of paid sick leave up to 3 times for 3 COVID-19 orders. If they're out on one order and they get to the end of it and they test positive for COVID-19, they're not allowed to return to work, and that is considered a new order, so they get to stay out again. Also, if an employer mandates that an employee not be at work because they think they've been exposed or had potential exposure, regardless of whether this exposure occurred at work, the Department of Labor in New York is now saying you have to continue the employee's regular rate of pay until you either let them come back to work or they become subject to a COVID-19 quarantine order, and then they would be eligible for leave under the law. So there's been a lot of writing already about this, about whether it's actually enforceable. So we'll see, but it's quite a dramatic change.
So in wrapping up, there are also some protections, we'll call them, that are sort of sneaky leave laws in this space. So some additional protections are included in Michigan, Minnesota, and the District of Columbia, because those entities have anti-retaliation provisions for employees taking leave due to COVID. You can see that the Minnesota and Maine laws have been around since 2005 and provide protection tied to quarantine or isolation order. Michigan's law is not a leave law per se, but it's an anti-retaliation provision, essentially protecting employees who are absent due to compliance with a stay-at-home mandate.
So I'm glad to hear Abby using the phrase I picked up, which was sneaky leave law. I probably have to come up with a more professional word for it, but COVID-19 has resulted in a lot of this. To me, Nevada is one of the most interesting. If you were to Google this law, it would show up as an immunity law. It only applies to certain businesses, including the casinos. It's hospitality businesses. And basically what the law says is if those businesses decide that they will comply with the safety requirements in this law, then they will be immune from certain lawsuits. Well, when you start digging into it and look at the requirements, there's what I call the sneaky paid leave in there, because they are required, the employers, to pay for time for employees to go get tests if they've been exposed, and to wait for the results of those tests. And then if those tests are positive, there's a requirement that they provide a certain amount of paid sick time. So this wouldn't necessarily show up on any lawyer's review of leaves that have been created, but it is, to a certain extent, if this law applies to you, it's going to be a leave mandate.
So in rounding out these sneaky backdoor mandates, we wanted to bring up Chicago, Philadelphia, and San Francisco. And these all have city level protections related to COVID-19 absences. And what they do is that they protect the employee from adverse action when the employee is absent due to COVID-19 stay-at-home orders or quarantine order. And so I think there is a public health policy behind this, is that they want people to stay home when they know that they have COVID or are contagious. And so they're preventing the employer from taking adverse action against those employees for complying with the stay at home.
I just want to note, when you see the blue underlined text in here, those are hyperlinks. We try to include hyperlinks for all of the laws that we're referring to. So now we're going to talk about remote work, which I think is here to stay, whether we want it to or not. And this is my, Abby and I are alternating slides, and it's hard for me to keep track whether we alternated, but I think this is my slide. The tax issues are a huge issue underlying this. If typically employees, it happens a lot in metropolitan areas. If you work in New York City, even if you live in New Jersey, you're paying the taxes of the state where you work. What has happened with COVID right now is that a lot of employees are being told that they have to stay home, and they're working in a state that they wouldn't ordinarily be working in. And so the historical way of keeping track of this may no longer be effective, and it has huge political implications, because the cities who now are more empty run the risk of losing lots of revenue. But it is an issue that will be, I think it's going to have to be dealt with in 2021 by the end of the year.
So Marge, I'm very glad that you didn't steal my slide, and that was your slide. This is my slide, because and I'll explain why I'm glad this is mine. So for state level leave laws, generally leave laws look to where the employee works, not where the employee lives. So if you have employees who are, who live in Connecticut but commute into Massachusetts, they'd be able to get Massachusetts leaves. Obviously, COVID has a lot of people who are temporarily working from home and potentially working from home in not their regular work state. So the Massachusetts Department of Revenue issued what they call a technical information release in April of 2020. And it was noting that the employee work state for tax purposes does not change if the employee is just working from home temporarily in another state. And of course, that's when we thought we would all be working home for maybe a month or a couple of weeks. And here we are 9 months later. So New Hampshire actually sued the state of Massachusetts over this rule. And again, Mass's rule was that it's subjecting non-resident earned income received for services at this point performed outside of Massachusetts to the Commonwealth of Massachusetts's income tax. So the cases actually got picked up by the Supreme Court, and 10 other states have filed amicus briefs indicating that there's a ton of interest in this and how it's going to shake out from a state tax leave perspective. So it'll be an interesting issue to watch in 2021.
So I predict, James will laugh if he's on camera, you can see him laugh, that I like to identify trends. And I actually think that an issue that could start to bubble up in 2021 is what employers have to pay for when an employee is working from home. I know that this is something that a lot of employers are struggling with, and they're trying to be fair, but there are state laws out there. California law, not surprisingly, is the most employee favorable, that you have to reimburse employees for necessary and reasonable business expenses. Another area that I think employers aren't necessarily as attuned into is that the ADA requires you to make accommodations in the workplace. And if that workplace happens to be the home, you still need to make accommodations if they're needed. And generally, you're probably going to have to pay for them. So I actually anticipate that if employers don't take a somewhat fair approach to this, this could lead to union organizing and other lawsuits. So I think it is something to be mindful of. The law is not completely clear. I don't know that you have to pay for everything that an employee uses at home to work, but I think you need to approach it that it is a sensitive issue that you could get advocacy groups picking up.
So we also wanted to note a couple other remote working implications. The first is workers' compensation issues. Employees can still recover under workers' compensation if they're injured while working from home and the employee can show that the injury was work-related. Employers also are still obligated to engage in the interactive process if they have a remote employee who's asking the employer to provide an accommodation. If an accommodation is provided after the interactive process and subject to the ADA, the employer has to pay for that accommodation. Non-exempt overtime eligible employees must be paid for all hours worked, even if you've told that employee not to work additional hours. So just a reminder that it's advisable to have clearly defined schedules and address work that you as the employer are observing that's happening outside of the schedule.
So we're going to launch into vaccines, which I know everybody is interested in. But before we do that, we thought we would stop, take a few questions, and then we actually have another poll for you. So I'm going to turn it over to James.
All right, we got a fair number of questions here. I picked out a couple repeat ones. So first one I think is for you, Abby. Can you talk about the Colorado? I think it was the Colorado paid sick leave law, and that you mentioned that was 16 employees. Do we know yet if that means 16 employees that live in Colorado, or is it 16 employees total for the company?
I believe it's if you as an employer have 16 or more total, but we can follow up with that person directly and give them the citation.
Yeah, lot of questions on this. So that was a pretty popular question on that new law. Another one, I'm not sure who this one is for, but if you have voluntarily offered the FFCRA this year, and your employee uses all 12 weeks, does that mean they've exhausted their FMLA leave since it was a voluntary offering from the employer?
So I'll talk to that because I don't know that there's crystal clear guidance, but the view we take, we do leave management, and we're very aware of what the Department of Labor has said and not said about when you can take away FMLA leave. And they've said things like, if you give FMLA leave to somebody who's not eligible, they haven't worked long enough, that doesn't count against their allotment. That the FMLA allotment only can be reduced when the FMLA actually applies. Well, here there is no mandate. And so I think that an employee would have a pretty good argument that you're doing, this is a voluntary employer provided leave that you're doing to get a tax credit, but that it shouldn't count against their FMLA time. A couple of the commentators that I've read support that view. I think it feels counterintuitive to most of us, but that is where it comes from, under the idea that this is not a mandate, it's voluntary, and so it can't be taken against the mandated allotment.
Marge, on the flip side of that coin, if they had taken that FFCRA leave during 2020 when it was mandated, I do think it would have exhausted the FMLA.
Yeah, and you can't, one thing that's clear is that whatever they took in 2020 is counted against what you're allowed to give them in 2021 to get the tax credit. They don't get a new 12 weeks.
I guess it'll be interesting. I mean, correct me if I'm wrong, but the Biden administration will write the new regs, right? I mean, that will clarify this question. Is that?
They may. I don't know how often it will come up. It would require an employer, it's going to be a very individualized, litigated situation. But yes, the Biden administration could come out with more employee. You should assume that to the extent things can be decided by the executive branch going forward, they're probably going to be more employee favorable than maybe they were in the past.
Could be Secretary Walsh, Mayor Walsh, from close to all of us in Boston, the Secretary of Labor nominee. One more question here, and then we'll go to the poll. Do either of you have a feeling around if you have COVID-19 or you have an employee that has COVID-19, does that need to be reported to OSHA in the OSHA reporting?
There are rules on OSHA reporting. Unless I read them, I can't keep them straight in my head. So we can add that in as a supplemental appendix item when we send out the slides.
Okay, and yeah, and also this, and we'll go to the poll question. Tons of people asking about the slides. Again, we're going to be posting the slides and the recording to our website, www.sunlife.com/coronavirus. So yes, the slides are, everybody is eligible for it. So you can see the polling question there on the screen. Again, we're big into polls now. We're interactive. We're changing our whole webinar structure going forward. So, you know, what are your plans? I mean, it's a good question. I can tell you my wife's nurse practitioner. She has been double vaccinated with the Pfizer vaccine. And I know my parents, myself, you know, ready to get in line as well. But we had a lot of questions also come in about vaccinations and requirements. I didn't ask those questions because Marge and Abby are going to get into that in our next section here. And let's see, yeah. Looks kind of, it's not 50-50, and obviously there's a few different answers here, but not sure what we're going to do versus not mandating. Those are the two leading things. So Marge, Abby, turn it back to you two to give us the details. What is the deal with vaccinating employees? Can we, can't we? What's going on?
Abby, I don't remember whose slide this is.
That's the challenge with alternating slides.
I think this one is yours.
All right, sounds great. So the EEOC has issued guidance specifically on COVID-19 vaccines. And, you know, it's a good news story for the most part. Employers may probably be able to require vaccination. Requiring vaccination is not itself considered a medical examination under the ADA, so that is good news. But if you are going to require employees to get vaccinated or even help them out with it, be aware that there are pre-screening questions that need to be done before you can be given the vaccine, and that can elicit disability-related information that you probably don't want to know. For that reason, the EEOC they're not quite recommending it, but I think it's a very good idea to have a third party administer these vaccines so that you don't have to worry about whether you're getting inappropriate information. You can also ask for proof of vaccination, which is very important to know. This is not considered a disability-related inquiry, but the EEOC points out that your follow-up questions might be problematic, like, well, why didn't you get the vaccine? And that answers to these kind of questions may also reveal that genetic information that can get you in trouble under GINA.
Great, sorry. So some additional items to keep in mind in regard to vaccines. Employees may ask for accommodations to not get the vaccine, either due to disability or sincerely held religious belief. I'm sure we will all hear more about this in the news, but there may be side effects of the vaccines that incapacitate employees. And lastly, even if the employer is mandating, there are likely to be availability issues, and still wearing masks may be required in the workplace despite the vaccinations.
So a lot of employers are wondering, well, if we're not going to mandate, what can we do? And there's been a lot of interest in incentives. So not to rain on the parade, but the EEOC just proposed new wellness rules that would really cut back on an employer's ability to offer an incentive to do a wellness type thing. They're saying only de minimis incentives like a water bottle or a gift card of modest value. I actually did read something today that the Biden administration, I'm not sure they agree with this limitation, so it'd be interesting to see how that all comes out. But other ways that you can help is that I think sharing information is key. Helping those employees who are afraid of vaccines or don't trust them. I think getting out the medical information about them is important. I think providing your employees with logistical information about where they can get the vaccines, how they can get them, where to make the appointment. And then, sort of going the full length would be making the vaccine available on site. That's very hard with the current types of vaccines that have to be frozen at sub-zero temperatures, but certainly making them available at no cost, giving employees time off, whether it's paid or unpaid, not only to get vaccinated, but to recover from the effects of the vaccine.
So now we're going to switch to non-COVID related development. Which I'm very happy to be leaving the COVID world behind. And if you move forward, we did have some things happen. If you flip to the next slide on the federal level. So there's 3 notable developments for the regular, old, non-COVID, non-FFCRA, FMLA. So the first of which is that in July, the Department of Labor announced that through year-end, telemedicine visits would qualify as in-person visits provided that the exam or treatment occurred, and that telemedicine was permitted by the state licensing board, and it generally should have been performed with a video conference. So this was nice. The FMLA regulations were written in 1993. They didn't contemplate telemedicine at that time. Obviously, telemedicine has grown so much, and particularly this year where it was safer in a lot of circumstances to have a telemedicine visit than to go into the doctor's office. So the Department of Labor actually affirmed the use of telemedicine in December, on December 29th. And so that's something that to be aware of, not a major change, but certainly useful, particularly as more employer health plans and more employees access telemedicine. The other changes are that there were new model FMLA forms and notices that were put out. The forms are more organized and they're better, they contain better explanations, which also comes with a longer length to the forms. They now include check boxes, they have more descriptions. They're not required to be used, but they're just the models that the Department of Labor publishes. And then last but not least, there were some developments on the requirement to have poster notices. So if you have a completely remote workforce, you can have electronic posting of the FMLA rights notice. If you have employees on site and teleworking, then you've got to still post that poster on site, a hard copy. But the Department of Labor encourages employers to use both methods and to have a traditional worksite poster, but also to post online. Just an important note that applicants and employees must be able to access the online posting of the FMLA poster.
So huge changes in California. We have a couple of slides on California changes, but the Family Rights Act has now gone from 50 employees. And then there was a law a couple of years ago that for parental leave, it went down to smaller. And now that it's gone down for all types of CFRA leave to 5 employees. This is reflecting a trend in laws generally, especially the paid family and medical leave laws. They generally apply if an employer has even 1 employee in the jurisdiction. So it is not surprising to me that this has happened, and California often starts trends. So it is possible that FMLA leaves throughout the country, possibly even at the national level, could start now to move down in number of employees covered. The family member definition was expanded. This is also a trend that is happening everywhere. The CFRA, it's amazing to me, it didn't cover military exigency, but it now does. And then they got rid of some unpopular rules under the FMLA, which the CFRA had, which was the key employee rule that you could deny leave to certain key employees. And then the married couple rule that if we had another 20 minutes, Abby could give you her view on that. She absolutely hates it. It was the only comment that Sun Life submitted to the new FMLA regulations was to get rid of the married couple rule.
Hate that thing. Other changes in California. The state expanded their victims of crime leave law. So starting this past January 1st, 2021, job protected leave became available to employees who are victims of crime or offenses that cause physical injury or that cause mental injury and a threat of physical injury. The leave is also available to an employee whose family member is deceased as a result of a crime. So that's an interesting new development that we'll see if it becomes a trend or not. It expands the type of documentation that the employee may provide to verify that the crime or an abuse occurred. And previously, prior to this change, leave was only available to victims of domestic violence, sexual assault, and stalking. So this is an expansion of the state's existing crime leave law. California Kin had a clarifying amendment, California Kin Care. A designation of a sick day as a kin care day is going to be at the sole discretion of the employee, and it can't be forced by the employer. So that's an important new amendment. The California paid family leave also was expanded, like CFRA, to include qualifying exigency as a leave reason.
And Colorado paid family and medical leave. Actually, Abby, James, and I all have been to the Colorado State House well, I didn't officially lobby. I was an amateur lobbyist. James is the only one of us who's officially a lobbyist, but we went to talk about paid family and medical leave, which was being considered as legislation last year. And we advocated for the inclusion of a private plan option, which allows employers to opt out of the state program and provide the benefits themselves. It has lots of advantages for employers. So that legislation didn't pass. Instead, everything went to the ballot, but luckily the private plan option made it into the ballot initiative. So the Colorado Pfml law follows the trend of Oregon and Connecticut, where there is not a separate allotment of medical leave and family leave. It's just 12 weeks. And you can use it for a variety of reasons, including safe leave, which is related to domestic violence. Colorado provides an extra 4 weeks for serious health conditions related to pregnancy or childbirth complications. That's much more generous than a couple of other states that have done this, where they've offered an extra 2 weeks. The benefit is staggered so that lower income employees get more. The premium is shared by employee and employer, which is a trend. These leaves don't begin until 1/1/24, but the premium contributions will begin on 1/1/23.
Another trend there, the premium run up starting early. New York, in addition to all the activity that we saw on impact to good old statutory disability and paid family leave, passed a paid sick leave law that's not COVID specific or COVID related. Under the law, employees started accruing time as of October 1st, 2020, with paid sick time available to them starting January 1st, 2021. And the amount of paid leave required varies by employer size. And the reason that leave can be taken under this paid sick leave mandate is for mental or physical illness, injury, or health condition of the employee or their family member. Note that the definition of family member is very broad. We've showed it on the bottom left side of this slide. You can also take leave to obtain diagnosis or for preventative care or for treatment. And you can also take it when the absence is related to the employee or employee's family member being a victim of domestic violence, sexual assault, stalking, or human trafficking.
So these are just 3 other noteworthy changes. The only one I really want to talk about at all is the Virginia law. Insurers are all in a tizzy about this law. It basically requires insurers that provide short-term disability to employers in Virginia to provide at least 12 weeks of disability benefits following childbirth. It's been very unclear whether that's a 12-week mandate or whether it's just that 12 weeks needs to be available if the person, after they have childbirth, continues to be disabled. We think in fact, we know that what the sponsor hoped to do was they're kind of creating a maternity leave policy. We've been trying to talk to them about, you really should do a paid parental or paid family leave law for that and leave disability to situations where somebody actually is disabled.
The marketing team must have taken out my publishing the Virginia senators' phone numbers to say, if you work or live in Virginia, call them, tell them you're mad about this. So moving on to pregnancy accommodations. You can flip to the next slide, Marge.
Sorry.
Oh, no worries. Okay, so you want to keep in mind your obligations as an employer for pregnancy accommodation. So under the ADA, complications of pregnancy can result in disability, as can underlying conditions. I'm just going to keep talking and hopefully we'll get the slides back for my marketing team. We're seeing the Windows logo on a blue screen and we're not seeing the slides. So anyway, on pregnancy accommodation, it's not required, but if there's an underlying condition that rises to the level of disability, or if the employee has an existing disability that is heightened or by the pregnancy, it may be considered under the ADA, and we're on a different slide. So Marge will find us.
Okay, I will advance forward.
Slide 42, I think. Pregnancy and or 43. Pregnancy and prenatal care are serious health conditions under the FMLA, so you have to be mindful that you have to give time under the FMLA for that. The Pregnancy Discrimination Act prevents discrimination against employees due to pregnancy or childbirth. And while there's no affirmative duty to accommodate, the Supreme Court in Young versus UPS ruled that an employer who accommodates one population at work must also accommodate, and specifically to accommodate those who are injured at work, must also accommodate pregnant employees. And then last but not least, under the Fair Labor Standards Act, the employer is obligated to provide breaks for lactation in a private space in which to express milk.
So all of those federal laws are great, but they have a huge loophole. And this case that was decided in 2019 really shows them. This was an employee who needed to she was hired as a manager, she had a baby, she needed to breast pump. And the only private place was the manager's office, but he had a huge window looking out into the hall, and he wouldn't let her put paper over the window. She had to turn her back to the window. There also was a security camera in this office, and he wouldn't let her turn it off. Male employees came in while she was breastfeeding. One male employee stood outside and sort of pretended he was breastfeeding. Ultimately, she ended up losing her job and she sued. Well, the jury was mad, as you can see. The jury awarded $1,500,000 in punitive damages, but the judge reversed the verdict and ordered a new trial. And what the judge said is, look, under federal law, there really is no right to sue if your employer doesn't provide you with a proper place to engage in lactation. The FLSA does have that mandate, but there's no remedy for it. And so the judge said a lot of the evidence was about how badly the employer acted towards the employee, and that really wasn't relevant.
So despite the lack of a federal law, you got to be mindful that the state laws provide much greater protections to pregnant and lactating employees. The states that we show here, bolded in teal, actually passed laws in 2020. And I looked up a couple of these laws earlier today, and just want to note that many of the leaves require the employer to make reasonable accommodations for employees and applicants due to the need arising from pregnancy, childbirth, and related conditions, including lactation. And many rules that many of them rule that the leave cannot be forced where the employer can make an accommodation. So if you can accommodate an employee who is lactating, you must do that before you force a leave.
Yeah, so this slide gives you even more of a view into some fairly common provisions of these laws. They're quite broad. They really send the message to employers that you need to accommodate employees. And it can include all sorts of things: transfer to new job, restructuring light duty. Some of them even say that for some of these accommodations, you can't even ask for medical documentation. You just have to provide the accommodation. I think what's really important to note is I predict, again, James's ears will perk up at this one, I predict that in 2021, we will have a federal pregnant accommodation law. The Pregnant Worker Fairness Act passed the House with a bipartisan support, overwhelming support, and it's pending in the Senate. And it seems to me like a relatively non-controversial law that hopefully we can get some bipartisan agreement on.
Would certainly make it easier for employers to comply, particularly multi-state employers. So with that, we're going to move into the final section of our presentation on FMLA and ADA case law. So friendly reminder that the violations for the penalties for violating the FMLA or ADA can include government investigations, lawsuits, damages that could include back and front pay and sometimes emotional distress, punitive damages for willful violations. And as the employer, you've got to pay your own attorney's fees, and sometimes you got to pay your employees' attorney's fees if they win their case. And those can get very expensive, as we'll discuss a little bit later. Last but not least, distracting the resources to to defend against a lawsuit are distracting and time consuming, and they consume your resources. So you want to avoid litigation. With that, we're going to go right into some of the recent jury verdicts. And we took out the case names here and went with some general titles. In this first one, we'll look at the state of New Jersey was the defendant, and the employee argued that the employer engaged in disability discrimination when it denied the employee's request for a 3-month absence to accommodate multiple sclerosis. And this employee had taken FMLA leave for a prior injury, and then she had developed some health problems for which she was seeking diagnosis, and it wound up being multiple sclerosis. And you can see that they found 1.8 million for her, including emotional distress and back and front pay.
So the next slide, we're not going to be able to spend a lot of detail on any of these, but we'll try to give some high level points. This next one it's interesting. It involved a major retail chain that shall remain nameless, but the employee had severe developmental delays, but he'd worked there for years, and he had a coach, an unpaid job coach that came with him through a public agency. And his job was to go collect the carts in the parking lot. But he couldn't drive the cart machine, but he had, over the years, other employees helped him do it. Well, what happened here is a new manager came in, and they didn't like this. They didn't like it at all. They didn't like that he had this coach with him. They didn't like that he was not able to carry his share of the burden in driving the carts. And so he ended up being fired. And so, as you can see, the jury was not happy about this, and there's $5 million in punitive damages awarded. I think the lesson from this one is it's not unusual when a new manager comes in that they don't like what's been going on before, but you got to look at it very carefully for potential legal risks if you start changing things that had previously been agreed to. It's not impossible, but it does require some tender care.
So in the next case, the employee oversaw the loading of cargo airplanes, and he was a manager, and he would oversee other people doing more of the heavy lifting, if you will. And this employee had a ruptured aortic aneurysm and was waiting to have open heart surgery, and eventually returned from leave and had a restriction that his doctor had written him a doctor's note saying he couldn't lift more than 15 pounds. And his employer refused to reinstate him with the restrictions. And actually in his separation, they actually told him, go collect unemployment, which came out in the case, which it never looks good when you're sort of snarky and mean as the employer. And he ended up collecting in excess of $1 million.
So this City of Reno case is one that I've actually talked about in other webinars. It involved a police officer who actually graduated first in his class from Cadet Academy. He had a promising future. And when a position opened for a lieutenant, he applied for it. And when he went into interview with the main hiring officer, he started off the interview by saying, I'm really annoyed with you about that FMLA leave you took last year. We had some questions about it, and you sent us some snarky emails, and, I'm just not happy about it. And he didn't get the job, but he still worked for them. So he sued, claiming this was FMLA retaliation because you didn't give me this advanced position because of the FMLA. I took FMLA. So the jury agreed with him. And the damages, you can see this category called front pay, $900,000. That's pay that's supposed to compensate him into the future for money that he lost. Well, he still worked for them. So the $900,000 was the difference between what he was making in his current job and what he would have made in the lieutenant job. Well, the case this year, the judge said, well, we don't think the front pay was really the right thing to do because he may leave and go get another job, or he might someday get promoted. So they took away the front pay order, they remanded it, and they ordered the employer that he had to get the next open lieutenant position and that he was entitled to his front pay award until that happened. So this is the main reason for this City of Reno case, is to just bear in mind, it's not just employees who leave that you can end up in trouble with. It can be employees who are still working for you.
In this next case, which the employee brought against the state of Wisconsin, the employee had a foot injury, and while she was at work, she had claimed that she had re-injured her foot at work, and she said it was caused when somebody stumbled into her and then called her a racial slur. It turned out that there was some video footage involved of that alleged second accident, and the employer decided that the employee had lied and terminated her. Aside from that sort of like accusation, the employee had been working, she had been assigned certain cases and was required to work a full-time caseload, even though she was only working part-time. And in that dispute, she had filed a grievance against her employer. And when this went to the jury found out that the employer had failed to accommodate the foot injury, and that the jury decided that the termination was actually based on the grievance and not on the fact that she had lied about her re-injuring her foot. So it was a sympathetic claim. And this is one where she had been working for a long time, nearly 20 years for the employer.
So I'm going to skip mine because we're running short on time. I do want to say that the one lesson I take away from that Wisconsin one is be very careful before you call employees liars. It's a very inflammatory thing to do, and a jury may not forgive you for it. So there are ways to handle situations like that when you're not sure they're telling you the truth without calling them a liar. Is this mine or yours?
I forget if it's yours or mine, but we show some recent Eeoc ADA settlements. It's important to note that the EEOC likes to come in and monitor the full workplace when they've received multiple complaints. And so, they'll do that. There's often lasting impacts of their investigation. So you just want to be mindful.
Yeah, the other thing I want to emphasize about this is that there weren't jury trials actually in 2020. The jury trials we talked about didn't happen in 2020 because the courts were shut down, but there were court opinions that discussed them, which is what happened in 2020. These EEOC cases, the EEOC was full on in 2020, and even under the prior administration, which had a reputation of maybe not protecting employees as much, the EEOC was pretty aggressive. And so I think that you can anticipate, we have another slide of major EEOC settlements just from 2020. I think you can anticipate that this will just continue into 2021.
With that, I think we'll wrap it up shortly. We put some of the impact of attorney's fees. This is kind of a commercial for outsourcing. These things can be costly, and even if the damages themselves are not traumatic, the fact that you're responsible for attorney's fees, your own, and if you lose the employees, it really adds up quickly. And so mistakes can be costly.
And then this is one of my favorite lessons that I try to tell my own client when they're mad at an employee who has left, is be careful before you sue them, because they then get defensive, they hire a lawyer, and they assert counterclaims. And so this particular case shows what can happen, which is that the employer sued because they thought the employee was violating a non-compete. The employee countersued for violation of FMLA. The jury found in favor of the employee and against the employer. And this employer, who thought they were going to get vengeance, ended up with a significant award of damages against them. So I didn't mention at the beginning, but I will mention it now. This session is eligible for 1 hour of HRCI credit, CE credit. SHRM credit, you can apply for it right away. The HRCI, I have submitted the program to be approved. It has not yet been approved, but I'm confident it will be. So you may just want to wait maybe a week before you submit the HRCI number. But so that you have that, it is HRCI is 547914, and the SHRM number is 2149CUM.
All right, Marge and Abby, I got a few questions, or a bunch of questions. A lot of them very similar, so I'm going to try to consolidate, I guess is the term.
And James, I'm sorry to interrupt, but before you go, we know we're at the end, and so for those of you who need to go, you're welcome to go, but we're relentless. So we'll stay and answer questions. So if you have questions that were asked that you're interested, or you're interested to hear what other people were asking, feel free to stay. We'll stay for maybe 15 minutes to the extent there are that many questions, and answer them. Sorry, go ahead, James.
No, I'm just a question guy. No problem. All right, so couple questions here, some a little more general. Again, I've tried to group some that have come together on the vaccine. We got a lot of questions, and both of you did a terrific job answering most of them. Is there any guidance right now on the type of proof that would be required, or the type of proof that an employer can ask to see, if their employee has got the vaccine?
So I have heard that there is talk that there's going to be a federal type ID card that people can use, because there are so many places that are going to be asking for this: airlines, hotels, places like that. So I think that with the new administration so committed to COVID and taking action, I think that we could have a federal solution. Abby mentioned that she's aware that that people who work in hospitals have little cards they can show. So I think that it won't be that hard to get creative. You're not going to be able to get a lot of information other than the date that it was given, and then the affirmation that a second dose was given.
Yeah, my wife has that little card. It's like a little index card. It's got the 2 dates on it. So Abby is correct. I can confirm that from knowledge. Nurse practitioner, my wife. Okay, for Virginia, you talked about the changes there around pregnancy, accommodation. Yep. I think one of the disability. Is there any broader implications that if you're from Virginia, or you have employees there, you have to be worried about right now?
So James, I'll take that one. That new change is for policies that are written on or after July 1st, 2021. So at the moment, if you just have an already existing short-term disability policy and you're with a carrier, you're not going to have any changes. Also, it looks to policies citest in the state of Virginia. So if you may have employees in Virginia, but perhaps your main office is in West Virginia and your policy site is there, you're not going to be impacted by this. So it's a limited impact, and it's something as an industry I think we struggle with, because it's describing a duration for a disability benefit that's not really tied to the person's disability. It's just a mandate based on a gender specific condition. So it's something we're watching, and I'm sure your carrier can give you more information if you have a short-term disability policy citest in the state of Virginia.
Okay, great, thank you. Another one, we got a couple forms this question as well on requiring a vaccine. Is there any size of the employer that does that matter? Does of how many employees you have, will that factor into whether or not you can require it?
I haven't heard it talked about in terms of size of employer. I think one issue is you're only going to be able to require it if the person comes into work. Like, I don't think you can mandate that your employees who telecommute get vaccines. The other thing that potentially could change with the mandate on the vaccines is that as we move into 2021 and more people have had the vaccine and we're potentially approaching some form of herd immunity, you may have to make more accommodations for those who for medical reasons or other don't want to get the vaccine. But for now, I have not heard any discussion about size of employer having an impact.
Marge, okay. I haven't heard any either, but I know you just quickly, Marge and I have been talking about, well, what do you do if your people can't get vaccinated? You can require it all you want, but if they don't have a place they can show up in a time where they can get their vaccine, then that presents another challenge. Go ahead. Sorry, James.
No. I'm just trying to facilitate. I'm not sure who this is directed to, but could you talk about if there's any direct impact to New Jersey's paid sick leave laws with COVID-19?
New Jersey has a brilliant development whereby they mandate that time be able to be taken during public health emergency.
Yeah, they amended their law specifically to include epidemics. So that will survive COVID.
Yeah, it wasn't a COVID specific change. It was in the event of an epidemic or public health emergency that employees would be able to utilize their time.
Okay, and this is sort of a catch-all question that we can, unless anyone else has any other, just please be able to type them in. You know, we went through a lot of different states on COVID-19 regulations and laws. Anything that you didn't have in the slides for any states that that, you know, maybe late breaking, or if people look, I think people are very interested in the appendix and all that information. Is that up to the, you know, that's basically up to date, I guess, is the question with
It
everything.
is currently up to date, but James, you actually, I meant to say this when I talked about the slide on Biden requiring new standards. I think there's going to be a lot of change in 2021, certainly at the federal level, which could be, as I said, good in some ways, because it may mean that the states and cities can relax a little bit and not be so worried about it if the federal government is taking over. But I do anticipate we're going to continue to see more. Another interesting trend that we've seen, to use one of James's favorite words, is there have been a ton of paid family and medical leave laws that have started being introduced. I think because a lot of states are strapped financially, I'm not sure how many of them will actually pass this year, but it's a real testament to how there continues to be a real strong interest in paid family and medical leave. And that I know that the COVID-19 paid leave is very high on President Biden's agenda. I also know that he also supports general paid family and medical leave. And the more you see states starting to do this, I think there is more likelihood that we could end up with a federal solution.
Okay, great. Well, you two have answered basically every question that that came in. So thanks everyone for tuning in today. Again, the big questions that just to remind everyone, as you can see on the screen there. Oh, Marge, if you could just go back for just 1 second.
Yeah,
the website. That's no problem. The website where the information is going to be posted is there. It's not going to be posted today, so you don't have to go there today, but very soon it'll be posted there. The slide deck, the thing. You know, Marge told you the information about the. Can Marge, you just go back, or whoever? Can you go back to the HRCI slide? That was the other. So those are your magical numbers there as well. So we'll leave that on the screen. But thank you, Abby. Thank you, Marge. Just unbelievable information as always. Thanks everyone for tuning in, and we look forward to seeing you at our next webinar. Thank you.
Bye-bye, everybody.